We are excited today to have as our speakers Ryan Flynn, who is a Senior Assistant County Attorney with the Ramsey County Attorney's Office, and Kim Larson, who is the Program Administrator for the Minnesota Competency Attainment Board. And I know they have a full program today, so I'm going to go ahead and just turn it over to them.
Great, thank you, Sarah. I am going to share our presentation. And I'll start off by just saying thank you to the Law Library for inviting us to share information about the Competency Attainment Board with all of you. We enjoy talking about this work. It's new and it's exciting, and we're really looking forward to hearing your questions at the end. Gotta make sure, there we go. So like Sarah said, I'm Kim Larson. I'm the program administrator for the Competency Attainment Board. I've been in this role since mid-January of this year. And prior to joining the board, I worked for the State Court Administrator's Office for about 16 years. And then prior to that was an attorney with legal aid, spending much of my time representing clients with mental illness and traumatic brain injuries. And I really appreciate that my career has circled back to working with that group of folks. And with that, I'm going to turn it over to Ryan so we can get into the substance.
Hi, everybody. My name is Ryan Flynn. I'm a prosecutor with the Ramsey County Attorney's Office. I've been a prosecutor for a little under 15 years now. I started out in Chisago County, was there for a while, and I started getting involved in sort of the intersection between mental health and the criminal process. And then I moved to Ramsey County in 2016, where I quickly became sort of joined in the effort to reform the issues surrounding the Rule 20 process. And I found myself in the middle of some legislative negotiations. There is some familiar faces here today too, who are familiar with that process. And it was a long process, and this was passed. And I was then asked to represent the Minnesota County Attorneys Association with the on the board for the Competency Attainment Board. And I was then asked to be chair, and we've been getting this up and going and off the ground. So I guess we can just sort of talk about what the issue is. We're going to be talking about a couple different things. First off, the history of this and how it came about, and then what was passed by the legislature. We'll talk about just some of the broad features of the legislation. We're not going to be going into an in-depth analysis of the statute. You're all competent people who can read the statute on your own, but just really talking about what was the basis and the intent behind some of these changes and where we are and I think where we expect to go. And then we'll be talking about the forensic navigators themselves and the services that they can render for a lot of the judges that you work with or cases that you work on. So first, building something new. So the 2022 competency restoration legislation, this came from an issue called the gap. I don't know if you want to go to the next slide, Kim, and all. So first, as many of you know, there's kind of two factors to somebody who has severe mental illness in the court system. There's the question of competency, and then there's the question of civil commitment. So civil commitment is a civil process. It is normally either a different judge or at a minimum, it's on a different calendar. And it's oftentimes different attorneys representing both the defendant as well as representing the state. And they have to make a determination as to whether or not a person has a severe mental illness, whether or not there's something else with that that makes it so that they are unable to care for themselves or creates an immediate danger or risk to others from that mental illness. Whereas incompetency is actually a constitutional standard that was elicited from the U.S. Supreme Court that talks about how a person needs to be present for their criminal case. And just because their body is present doesn't mean that they're mentally present. And they laid out what that means in terms of they have to be able to understand the charges against them. They have to be able to understand the roles of everybody in court. They have to understand the role of their attorney and be capable of speaking with their attorney. Kim, is there, I think there's some animations here. All right, so obviously, again, your criminal case starts out, the goal is to bring some sort of accountability or stability to that individual, to the community, and you have these two very different standards. The problem is while our civil commitment was a legislative standard, incompetency was a constitutional one, and they did not match. They did not meet up. So where incompetency ended, civil commitment did not begin. And this was called the gap. And it was a very sincere legal gap. And what was happening is that you would charge people for very serious crimes. They would be found incompetent, but they would not meet the criteria for civil commitment. And they couldn't receive any services. Criminal courts did not have jurisdiction. Their cases would simply languish in the system with a couple of review hearings without treatment, without supervision, and very often with ongoing problematic conduct. Do you want to go next slide? So this naturally gained a lot of attention. Eventually, a lot of news organizations caught on. KARE 11 did a very robust investigation. You can sort of see they adopted what lawyers were referring to it as. Lawyers called it the gap, and reporters adopted that phrase. You can also see, if you look closely, the sort of inflammatory language to just sort of to talk about this when they were reflecting public sentiment about it, the failure to treat, failure to protect. There was a lot of people very concerned about this. And so multiple attempts were made to fix this gap. There were proposals from the Minnesota County Attorneys Association. There were proposals from other groups. Eventually, a task force was formed. That task force made proposals, but there was real problems with that proposal in terms of some pretty strong objections from multiple members of the community about how that proposal would have been applied. There was also objections to the MCAA's version, what they wanted to accomplish. And long story short, this is what came out of the state legislature is absolutely a compromise packet of legislation. Next slide. So if you review this legislation in its entirety, you will at times feel like there are some conflicting goals, and there are portions of this language that may feel like you are being pulled in different directions with what a judge is supposed to do or what parties are supposed to do. You're not crazy. You are not imagining that. This is a negotiated bill that really attempts to comport with multiple goals and multiple concerns with both the system and the legislation. So that was created in 2022. It was supposed to sort of take off relatively quickly. Unfortunately, there was a typo essentially in some of the omnibus language as bills were being stacked on top of each other, and eventually came into this omnibus bill, and the language funding the agency and the board had a different effective date than the effective date for the statute. So that had to be changed. So that was amended in the 2023 legislation. So the effective date was pushed back. The legislation was to come into effect in 2024. We were appointed, half the board is appointed by the governor, the other half is appointed by the Supreme Court. We were appointed in June of 2023. And our first meeting was in July of 2023. So we already had less than a year to launch an entirely new state agency with a pretty big demand on it. So the big changes for the courts are going to be, once this statute took effect in 2024, it really reflected the normal Rule 20 process, in that the competency, once it's raised as an issue, they need to address it. They need to determine if it's a legitimate sort of concern from the defense or from the state. They got to order an examiner. Examiner conducts the examination. There can be a contested hearing if it's contested, and then the court makes a determination. So there isn't significant change with that sort of core process. However, the court does have a lot of discretion with its timelines. There are some guideline timelines of, I think, 30 days, 60 days around, but in most of those timelines, district courts have the ability to sort of waive that with good cause. But how that procedure applies, we really broke it down into 4 different avenues: misdemeanors and targeted misdemeanors, gross misdemeanors, felonies. And that's because one of the concerns is felonies and gross misdemeanors were being treated in the same way under the old system, and misdemeanors were just outright dismissed, whether they're targeted misdemeanors or not. And when looking at targeted misdemeanors, if you don't know what I'm referring to misdemeanors that have been shown statistically to be likely to be offenses that likely have reoffense. So those are your DWIs, your domestics, your OFP violations, your fifth-degree assaults, your indecent exposures. And what we found with under the old system is, particularly like with domestic abuse, we couldn't do anything about it because they start as misdemeanors and then they would just pile on. And so somebody would come into the system with multiple domestic abuse cases that all got dismissed because they fell into this gap, until finally their conduct was so violent or so troubling that they jumped from misdemeanor assault all the way into felony, and many times felony murder. And that produced either a lifetime sentence or a lifetime commitment. So that's why we really broke down those misdemeanors from targeted misdemeanors. And moving on, looking at the gross misdemeanors, misdemeanors and targeted misdemeanors. So again, misdemeanors, presumptively, we don't want to keep people with severe mental illness in the system appearing for hearings, particularly if it's a low-level offense. So if it's just like a trespass or disorderly conduct, a lot of people have severe mental illness. They'll go into a coffee shop, tell the coffee shop owner that they own the place and they're also a princess of the royal family. So these are us rather being like deeply concerning criminal behavior. Those to us are more like cries of help. So the group that negotiated the legislation really quickly agreed that those are the cases where they don't need to be in the criminal process, but they should still receive referrals for treatment, referrals for perhaps housing. So that's why even misdemeanors still get, once the agency is fully up and running, they should still have bridge plans, things like that, so they can get those referrals for treatment. But your targeted misdemeanors, rather than waiting for them to come back with more serious offense, a targeted misdemeanor can be looked at by the state and they can decide, is this something that we just, brush aside, let them have the referrals, see if they come back, or if this is something that we need to have more investment in. And that's why, if the state chooses, they can file notice and they can have a full year to pursue that case and pursue a return to competency before that case has to be dismissed. Now, gross misdemeanors are a little bit different. We want gross misdemeanors to receive some attention. But again, if the prosecutor looks at that case and decides that this, it's a gross misdemeanor theft and it just happened to be $550 or something like that, so it's still not necessarily a major public safety risk, they can just agree to let it be dismissed 30 days after the finding of competency. Or they can ask that they go into the competency process for up to 2 years before that case is dismissed. Felonies are a little bit more complicated. So felonies, they have a 3-year lifespan, unless it's a crime of violence, in which case it has a perpetual lifespan until it's decided that the state is just never going to be able to return this person to competency. But so the required exams under the old rule is at once every 6 months. Now that can at least be pushed out to 12 months if there's agreement by the parties in the court. And parties, of course, can always ask for additional hearings if somebody's returned to competency or if there's some sort of change in circumstance. And the defense can always file a motion to dismiss in the interest of justice. So, for example, oftentimes we see this with like 5th-degree drug possession, where somebody, it's a possession of a small amount. They get into a stable place and it just doesn't make sense to continue prosecuting that person. It could impact their housing. Then at least the defense can make a motion to the court that this isn't worth the court's time nor the state's time. So what does that mean? Somebody's in this process and they need to get this programming. Well, we really talked about there's sort of generally 3 types of programming that a person can receive. There's that has proved successful in other jurisdictions. There's jail-based programming, there's locked facility programming, and there's community placement. And they're pretty self-explanatory. Jail-based programming within the jail. So while they are in jail, they are receiving care and programming that is geared towards mental health treatment, oftentimes neuroleptical medication. Locked facility, that's your Anoka Treatment Center. That is your St. Peter. That is your locked IRTS facility. And if you're not familiar with a IRTS facility, it's an intensive residential treatment center, which tends to be considered the gold standard for a lot of these cases for being able to receive treatment. Now, the locked IRTS facilities was a separate bill passed in the same legislative session in which an IRTS facility could be locked and there was grant funding set aside so IRTS facilities could become locked IRTS facilities. That transition has really not taken place to any significant degree. DHS was in charge of a grant program to help with that transition. No IRTS facilities applied to be a part of that grant program. Therefore, obviously, none received the grant money and made that transition. So there is ongoing conversations about what IRTS facilities need so that they can feel comfortable in making that transition. I think that there is a lot of concern from IRTS facilities and program administrators about how being a locked facility conflicts with their mission to be more of a community placement program. And there's also concerns, I believe, of how that will impact their facility and the safety of their staff and the safety of other patients if they're a locked facility and they're receiving people directly from jail or DHS who have very serious charges. So these are sort of a complex conversation about trying to make locked facilities not solely dependent on DHS. Community placement facilities, again, that's any sort of facility that doesn't lock the door. And there's other ones in the statute as well that talk about like sort of alternative program placement, like might be the Salvation Army or some other drug treatment-based programming where somebody can receive then some treatment there, at least stable housing, and then they'll just have to receive their mental health treatment from another source. So bluntly speaking, the hard question is we need to find available programming. So forensic navigators are successful in other jurisdictions. We are successful in Minnesota. We are assisting with these cases. But we cannot magically produce the beds needed for many of these clients and defendants. Minnesota ranks at the bottom of the 50 states for emergency mental health placement per capita. So in terms of per capita question, Arkansas, Missouri, Texas, Nebraska, they all have more emergency mental health facilities per capita than Minnesota does. We are 50 out of 50. So that is a significant question that still needs to be addressed. There was some, again, as we talked about with the grant program, there was this real sincere attempt to address it. We just hadn't seen it play out the way that we wanted it to. Conversation about having beds at DHS and DHS facilities, expanding those facilities. That is an open question and a debate. If you've been paying attention to what went on in the last legislative session, that was a big topic about DHS getting more beds for people who are committed as mentally ill and dangerous and also who are currently in a jail setting. DHS also, there is a representative from DHS on our board, specifically from DCT, Direct Care and Treatment. It is, I believe, sincerely a goal of DHS to try to get treatment, competency treatment to people who are not yet civilly committed. I believe that because the way that it is talked about as that is early intervention, and then we can get people off the track towards civil commitment if they can get competency treatment and some stability in their lives before they meet the criteria for civil commitment. So, Kim will talk about that a little bit later. They are one of our programs that people do receive referrals to, but so they are right now a good partner. And again, placement options, it does require the the consent. So it's not something that the district court can force somebody to take in. So when we're talking about treatment, what does that really mean? What is competency treatment? Well, so there's been a lot of guidance on this already. The vast majority of people who are not competent need two things: a stable place and stable meds. If you get them neuroleptic medication and you're able to get them that medication directly and on a sort of consistent basis, and that person has a stable place, whether that's a treatment facility, whether that's an apartment, whether that's a jail cell, they tend to become competent fairly quickly. So when we talk about housing and neuroleptic medication, understand that those two things will tend to resolve the vast majority of competency issues. Competency restoration programming is another facet that is not necessarily linked to neuroleptic medication. So even if you have zero programming, the majority of people will still become competent if they have consistent neuroleptic medication and stable housing. However, competency restoration programming helps, and that is your clinical plus your educational. Your clinical, again, that is therapy, having a therapist or a psychologist, doing group programming. If you've toured at all in NOCA or St. Peter, you'll know that group and group work is a big pillar of their programming and what they do to help people. So that clinical aspect is very important. An important part, but probably bluntly the least important part, is actually the educational. So the educational really is you are teaching them and walking them through what the legal system is. So you're talking to them about the role of their attorney, the role of the judge, the role of the state, what their charges are, what kind of sentences they can expect for different levels of charges. It, again, is this important tool, but you really only require that educational programming in a pretty small section of the population that we're talking about. Normally, your educational is going to be more appropriate to be sort of the flag about when somebody has obtained their competency. So once they're retaining that information, they're understanding it, they're able to repeat it, that will be sort of the sign to the instructor of, okay, this person has reached competency. And now, assisted by forensic navigators, the only caveat I'm going to give to that is, again, assist is the intentional word. So forensic navigators are not doctors. They're not board certified psychologists, so they cannot provide neuroleptic medication or administer neuroleptic medication. What they can do is they can do referrals, and they can help people, and they can help people attain this. We are working on being able to help administer that educational facet because it's only going to be necessary in a small subset of cases. It's not it's not the biggest priority. The biggest priority is being able to get our forensic navigators to help identify places where our folks can go and get that more critical, competency restoration program. So then, of course, the question was, who oversees this? This is a huge operation. It's significant. And I want you to know that the questions were already asked. Well, why isn't this a county board thing? Why don't counties administer this themselves? The county said that they didn't want to touch it with a 10-foot pole. And I understand that because I think they were worried that they would be on the hook for both results as well as aftercare, things like that. It was not something that they were interested in doing. Well, why doesn't DHS take it over? Nobody wanted that. DHS didn't want that. The legislature didn't want that. Advocates didn't want that. DHS and DCT, they have their own very big issues that they are trying to wrestle with and resolve, and we didn't want to add this to their plate. So then there was a conversation about, well, the forensic navigators really are assisting judges in administering the most just outcome that they can obtain in some of these cases. So let's put it with the judiciary. The court administration did not want it under their umbrella either. And so we'll move on here to the next slide. So basically we stuck it in the judiciary. We stuck it in the judicial branch. We are a judicial branch agency. We are not an executive branch. Um, and but we need to be governed by something separate than the Judicial Council and the court administration. So we have our own board. We're a 7-member board. We have a variety of mandated backgrounds, including somebody representing the county attorneys, someone representing the public defenders, somebody representing psychologists, someone representing DCT, and somebody representing the public. And specifically, we have an advocate from the National Alliance for Mental Illness, NAMI, Minnesota branch. So we also have somebody representing caseworkers and somebody representing probation and pretrial supervision. So we have a lot of professional backgrounds. And so we've been working at creating a statewide independent process that can certify these competency attainment programs while also hiring, administrating forensic navigators so that they can promote the prevention and sort of the stability that we're looking in these cases. So I've thrown a ton of information at you, and I'm just going to sit here and drink some tea while Kim throws a ton more information at you. So I will tell you a little bit of background that we operating a state agency on its own is a big demand. And we were finally able to get the structure to hire a program administrator in December. And so we immediately started looking for someone, and we found Kim, and we're very, very lucky to have her. And we shamelessly stole her directly from the state court administration, and who helped us with that process a little bit. And so thanks to them for letting us steal her away. And we hired her again in January. And when she was hired, we met for coffee, and I said, welcome. And now you need to create a whole new state agency in about 3 months. And that's essentially what she did. So I'll turn it over to you, Kim.
All right, thanks, Ryan. Let me just be clear, we are not done yet creating that new state agency. There's so much that goes into it. But I'm not going to talk about those logistics today. I'm going to talk about the work that we're doing and the people that we're hiring and what things look like for us in these early stages of implementing the new legislation. So what you see here is a future-looking organizational chart for the Competency Attainment Board. It might be a little bit hard to see on your screens, but just to kind of call out right now, the positions that are in blue font, if you can see that, are positions that we currently have filled with individuals. So I'll get a little bit more into the detail of our personnel going forward, but this just kind of gives you an idea of where we expect to grow in the next year to probably 3 years. So looking specifically at where we are right now, we have 15 forensic navigators who have been hired. As you look at the map, the location where the stars are, it's probably obvious that's where they reside around the state of Minnesota. We have 4 forensic navigator supervisors. We have a human resources manager, an IT manager, and myself. And we are currently in the midst of a hiring process to bring on more forensic navigators before the end of this calendar year. And just to give you an idea of what we're planning for, by the end of this fiscal year, so the end of June 2025, we're looking at potentially bringing on board another 60 to 70 forensic navigators, along with some other central office support staff. So by the end of the fiscal year, we are potentially looking at a personnel group of about 100 individuals, which is kind of shocking to hear me say that out loud, considering we'll be about 1.5 years into our work at that point. So, like Ryan mentioned, one of our primary responsibilities is providing forensic navigator services. So these are services that no particular single person has ever really provided in the state of Minnesota before this was created. So there's definitely guidance in the statute. You can see I referenced it there. So if you're interested in looking at the specifics that the statute sets forth, you know where to find that. But then there's other things that wrap around those responsibilities and those tasks that we've learned we need to do also to be effective. So the screenshot here is a document that we have on our website that's called Forensic Navigator Services. You're welcome to look at it, share it broadly, print it, tape it up and stick it up on your bulletin board, whatever makes sense for you and how much you want to know about this. But just as a quick reference, what forensic navigators do is they write bridge plans. That is a role that is set forth in the statute, and it's meant to give the court and the client an idea of how we're going to try to help them meet the services, get the services they need while they're in that gap space that Ryan talked about. It gives us a way to connect with them and figure out what our next steps with them are going to be. Navigators also participate, not themselves. They make sure their clients participate in court-ordered examinations, that they show up for court hearings that are scheduled and any other appointments that might be relevant to their clinical therapeutic treatment services. Navigators also work on coordinating placement in the court-ordered programs that Ryan mentioned earlier. They are and will be providing education, the competency attainment education. We're still in the early stages of that, so still really figuring out what that looks like. And then they also will report to the court on the progress that the defendant or client is making towards competency. And then just overall making sure that that individual stays engaged with the services that have been set up for them. And that's often looking like coordinating those services with other providers and other professionals who are working with the individual. Excuse me. So to be involved in a case, the court has to appoint a forensic navigator in the case. When that happens, the court administration staff sends the order to our central office. Our supervisor group monitors the receipt of those orders and tracks them, and then determines assignment of navigators based on a set of criteria that I'll share with you on the next slide. Once we determine if a forensic navigator can be assigned in the case, we file what's called a notice of assignment with the court, and we indicate the results of our screening. So right now, that if we're assigning a navigator, we provide the navigator's name and their contact information in that notice of assignment. If we are not assigning a navigator, we do notify the court of that, and then we provide the reason why we're not assigning a navigator. Probably obvious in our discussions, but just to state it out loud, with only 15 forensic navigators hired so far, and well over 1,000 cases that we've been ordered in, we just don't have the people capacity to assign a navigator in every case right now. So that's why we have this criteria and screening process to make sure that we can get folks assigned in the cases that are either where we'll provide the most benefit, or where it's an area of the state that we have navigators available. Once the assignment happens, navigators start their work in the case, and that often begins with trying to contact the client, the defendant, and then reaching out to everybody else who may or may not be connected with the individual at that point in time. So I'm going to circle back just quick and talk about our case screening criteria. So like I mentioned, this is criteria that we've established in this early stage while we have limited resources. It helps us quickly look at the orders that we're receiving and determine which ones we can focus on for assignment. Some of these criteria may shift over time as we hire more navigators and get more up to speed with the orders as they're coming in. So our first factor, of course, is whether or not there's a resource available. That might just be a sheer number question, but it also might be where in the state our navigators reside. So we're attempting to establish service areas that do not result in navigators spending a lot of time in their cars driving to meet with clients. So we do factor in the geographic pieces of where we've been ordered and where navigators live. We also screen out right now cases where if by the time we get a chance to look at it, the defendant has been committed, we are not assigning navigators in those cases. They're also if they've been found competent or if the case has been dismissed. So in those instances, we're not assigning navigators. Occasionally, we get an order where it is for a Rule 2002 exam only, and we're not appointing or assigning navigators in those cases. And then juvenile cases are outside the scope of the statute. So we have gotten orders in just a small number of instances that were within a juvenile case. So we screen those out as well. Right now we have, like I said, over 1,000 cases that we've been ordered in. Our current pool of 15 navigators are representing clients in about 300 or so cases around the state. So a pretty small percentage. We're still growing their caseload. We're still trying to figure out what the right caseload is for a forensic navigator. We know there's some factors that play into it. We don't ever expect that we will have a standard. Every forensic navigator has 25 cases at a time, just because of how the cases move through the system. There's different needs at different stages of the criminal case. There are different needs for every client. Some defendants were not able to locate, so there's not a lot of work that a navigator is actively doing in that case. And then, of course, the distance that a navigator may have to drive to meet with the client or attend court hearings is a factor in how big their caseload can be. So we expect that caseloads will just continually fluctuate for every navigator over time, depending on the status of each case that they're assigned to. So I'm going to move on to competency attainment programs. This is the other component that Ryan talked about. We're required to establish and oversee based on the statute. As Ryan mentioned, these are often community-based programs. The statute does set forth standards specifically for a program to be certified as a competency attainment program. The statute also sets forth standards for jail-based programs. And then it also states that we're responsible for doing data collection on what happens within those programs and reporting it back to the legislature and other state agency partners on an annual basis. So part of what the statute also sets forth is that the board is to establish procedures for certifying programs that apply to be a competency attainment program. There are interim procedures that have and were approved in March of this year. This link here will take you to those procedures on our website. Since those have gone live, we have 3 programs that have been certified. So North Homes Children and Family Services in Grand Rapids, Minnesota was the first program. They are a community-based non-residential services program. The next program that was approved was is the Hennepin County Behavioral Health Center. And then Anoka Metro Regional Treatment Center has been certified as a competency attainment program. Forensic navigators have been referring clients to all 3 of these programs. Clients have been admitted to all three, and many of them, just because we're still so early in the process, are still receiving services through those programs. So we don't really have results-based data yet to report on or talk about, but it seems so far like everything is moving like we would expect, and it's pretty exciting to figure out how to connect folks to these programs. So the other aspect of this that I want to just call out before I turn the presentation back over to Ryan to wrap us up is there is also a certification advisory committee established in the statute. Their purpose is to provide the board with advice and expertise related to the certification process for competency attainment programs, including jail-based programs. So the detailed information about the committee is available on our website. The statute does set forth standing committee members based on their affiliation with different justice partners. And then there are 3 positions that are appointed positions by the governor. That committee meets on a monthly basis, and they are starting to wrap their arms around what a certification process looks like. They also will begin digging into the details of the competency attainment curriculum that the board approved initially last September and is also available on the website. The plan is to look at that and create some additional training materials, some additional substantive information that can be used to provide education to the defendants in those instances where education is a critical component of them attaining competency. So, Ryan, I will turn it over to you to finish up.
All right. So one of the last things I want to talk about is the certification advisory committee. That was something that those of us who are negotiating the language in this bill and asking the legislature to support us with the language of this bill, we wanted that. And one of the issues with advocating for the folks in these types of cases, for this type of population, is that there was never really a clear and coherent champion for that group. So there was nobody who really would come forward and say, this is what we need to do to make it just a little bit better, and making it a little bit better makes a huge difference. And we found that that was really an integral part to what allowed the gap to come into fruition and remain for so long. And so we also added into the duties of the board that we are essentially supposed to be data keepers, not necessarily private patient information, but data keepers. And one of the primary goals is to look at what is working, what is not working, where are the changes in the law that need to happen so that we can finally be done with this gap. And there's a lot of information out there, but those who know about the history of mental illness and treatment by societies for a very long time, the treatment was, if you were suffering mental illness to the point that you were a problem, we took you out of society and we locked you away. And it wasn't until that was undone, but then there was no services put in place to really help the people suffering severe mental illness. And so we're trying to figure out what we can do in conjunction with so many people. And once we have that information, again, to keep under our statutory obligations, is we have to keep making recommendations to the state legislature about what we can do. And the whole purpose of that is to recognize that we are not building this to be done. The statute will change. The statute will grow, it will shrink, it will be amended. And that is intentional. And we did that as we were writing the statute, we recognized that. And so many of you are going to find that there's maybe lack of clarity in some spots, or maybe there's certain cases that are just sort of a conundrum under the language. That's okay. We want to hear about that. We want to hear input, and we want to know what works and what doesn't work, because that is part of our statutory mission. And the whole point of that is, go ahead and switch to the screen, is we want to close that gap. We want this to be a clear line that we can move people from incompetency through competency pursuant to their constitutional rights and find some sort of both accountability and stability for the communities that these folks live in. And if nothing else, peace for the victims who may have been victimized by some of the conduct. And we'll go to the last one. I just want you to know how achievable this is. We did look at other jurisdictions and what they're doing, and specifically, there was a jurisdiction where the program, now the caveat to that is that everybody who entered this program did so voluntarily. So they were ordered to do it by the court, but the court made sure that they wanted to do the program before they went into it. And they had access to neuroleptical medication. They were in a separate portion of a locked facility, so a branch where they were able to have access to clinical treatment as well and group therapy sessions, again, along with that neuroleptical medication. And what they found is actually a majority of them were returned to competency within 60 days. And then a majority of the remaining people were returned to competency within 6 months. And then a big chunk, but not a majority, but a big chunk of the last people who remained were returned to competency within a year or year and a half after that. And the people who remained were the very deeply complicated cases. And that would really be the population where civil commitment would be more appropriate. And so consider how many people were off-ramped from the civil commitment process from that program because they were able to return to competency, the vast majority within 6 months. And that really showed how much of a failure the Minnesota system was when, for those of us who are familiar with it, it was years and years and years of review hearings. So thank you for listening. I don't have anything else. This is an achievable goal, but it's a moving one. And so I really appreciate you all being here. And I'm happy to answer questions.
We have quite a few questions in the chat for you. I will relay the first one here. You should be able to see them as well. The first question, was there an intent to differentiate between language that charges are dismissed X number of days, years after the date of the finding of incompetence, while others are dismissed within X number of years after the finding of incompetence? Essentially, does the within mean something?
That will be up to district courts and Court of Appeals. I can say that when we were writing it, no. The majority of the language that you hear, the technical language, is copied and pasted from other rules and statutes and processes that the group was able to agree worked. And so a lot of this is copied from other statutes that were in existence at the time. And then we modified and amended them to suit our purpose. So the rules, the language of within was a distinction that I don't even know if we were aware of because that wasn't our concern. Our concern was talking about what year they would be dismissed, whether or not crimes of violence could be dismissed, things like that.
Thank you. The next question, what can forensic navigators do for those who are found incompetent because of cognitive impairment rather than mental illness?
Cognitive impairment is always going to be one of your more complicated cases. My understanding is examiners frequently talk about there are some cases where a person can be brought back up to competency, and a lot of that is going to have to do with stability and that educational component, where a person may not be so, if it's a cognitive impairment, like for example, developmental delayed, there is a level where they can retain enough information where they can be returned to competency if they have enough access to educational and sort of stability. There are other folks where that's just not going to be, that's not going to be possible. A common one is TBIs, traumatic brain injuries. This was always an enigma because from a prosecutor's perspective, there are cases where we would see somebody who had suffered a severe traumatic brain injury, and then a year later, they do return to competency. And in speaking with a doctor, kind of what they said was, TBIs are not well understood. And in the end, some people are able to obtain that competency, and some people just will never get it back. And the only thing really what he said was stability and time will tell. And so that was one of the things that we were thinking about when we said we can do yearly reviews as opposed to always having to have 6-month reviews. We TBIs was a big part of the conversation when we changed that.
Thank you. The next question, you may have mentioned this, but I missed it. Do forensic navigators have any fiduciary duties to defendants?
Kim, I'll let you answer that.
I can take that one. You didn't miss it. We didn't specifically talk about this, so it's a great question. Forensic navigators play a neutral role, so they are not in a position to advocate for what specifically what a defendant wants. Their role is to look at the totality of the circumstances around that individual and really make recommendations based on what will best assist that person in attaining competency. And we know that, you know, in some instances, what the client wants doesn't necessarily match with what services will help them achieve that. So they do not have a fiduciary duty to the defendants. Their role is to remain neutral and make the best recommendations they can to help them attain competency. So hopefully that gets at what you were asking about.
Great, thank you. The next question, should courts still be referring defendants for commitment screening pursuant to Rule 20 or just requesting a forensic navigator?
I know that there was a proposal to change the rule, and I know that's under review by the Minnesota Supreme Court. I guess I don't think that they have issued their final decision on that. So I believe the controlling rule is still that district court should be referring for civil commitment. There was not a big push to change that at this time. I think it was sort of like almost like a minority report where they asked maybe we should be changing this rule. I think the rules committee is recommending to not change that. And a big part of that is because the forensic navigator services have been in effect for less than 6 months still. So we are still growing and kind of getting the legs underneath us. And so the idea is people should still be regularly reviewed for civil commitment because they might be able to get their services more quickly and more appropriately through that process. So while there is a sort of an end game in sight where eventually that will not be automatic, my understanding is that right now district court should still be doing that automatically.
And we are seeing that that is still happening frequently, more often than not.
Great, thank you. The next question, is the intent under section 611 to still dismiss misdemeanor, gross misdemeanor charges if the defendant has enough custody credit, even if it's less than the 1 or 2 year period?
I would have to double check the language. So what I would say is, so I practice in the felony sphere. So I at this point only do homicide cases. So I can't say definitively. So I'm operating from memory. So I haven't looked at the statute for a while as it regards misdemeanors and gross misdemeanors. My recollection is the answer would be no. It's not an automatic dismissal upon obtaining custody credit, but it would be they should be released from custody. And I believe it's because we were thinking of those targeted misdemeanors, things like that, that could be enhanceable offenses. There can still be a state interest in obtaining the conviction, even if there is no possibility to have probation or any additional time in custody.
And adding to that question, person has added, what about for felonies?
Same.
I don't see any other questions here. If people still have questions, please feel free to enter them into the chat. We've got a few minutes left before we need to wrap up. So if here's another question. Who should we email if we have later questions?
I think you can, yeah. I think Kim is going to be your best resource. You can also feel free to email me. You can also email Elliot. He's the vice chair of the board. We're happy. Thank you, Kim. Good thinking. Kim put her email in the chat. Um, we're always happy to answer questions.
And I did have a couple of other questions, whether this recording and the slides would be available later. And yes, those will be available later on the State Law Library website. Again, I'm not seeing any additional questions. I don't know if you have any closing thoughts that you would like to share before we wrap up.
Well, I'm a lawyer just like many of you, so I can always talk a little bit longer if you need me to. Um,
I actually did just get another question here.
oh,
The,
perfect.
the question is somebody from the criminal defense bar part of the board?
Yes.
Okay.
Yes. I think they're actually here too, but I won't call them out in case they were hoping to scooch by with some CLE credit. Well, I guess I can say this is, again, thank you everybody for coming. You know, we recognize that the statute is going to change and adapt over the years. And the real goal is when many of you are sort of seasoned practitioners or retired, or some of you maybe even judges yourself, you can talk about the days when there was zero programming and when there was this gap in existence, and instead be frustrated when you're with your cases because you are trying to decide which program for competency restoration you should be referring a defendant or advocating for a defendant to go, not dissimilar to what we do with treatment programs about who has the available bed and which one is best for a specific person and their circumstances. So that is the goal. I do think we'll get there. Just we all got to buckle up and realize it's going to take 5 to 10 years before I think we really see the intended result of the statutory fix.
I would just also echo the thanks. Again, it's great to be able to get information out. And if any of you are part of groups or teams that want to share information with the rest of your team, we're happy to do other. So feel free to reach out and request us to come to a meeting or share information in other settings. We're more than happy to get the word out. So, and thanks Sarah and the Law Library for hosting us.
Absolutely. Happy to do it. Um, we have gotten a couple of more questions, so if you have time to answer those. One of the questions is similar to the last one. Is someone from the Civil Commitment Defense Bar a member of the board?
Yes.
Okay. And then an additional question, if someone is restored to competency, is the expectation that their work with CAB and Navigator is taken into consideration with any sentencing, i.e. treatment court adjacent?
I mean, I think that would be the advocate dependent. So the defense attorney would have to make that decision in whatever the case, what treatment was or wasn't accomplished. And I mean, I think that would be, I don't know why a judge wouldn't consider a defendant's successful completion of a treatment program in their current stability or instability in assigning a sentence, similar to the completion of chemical dependency treatment.
Great, thank you so much. That's all the questions I see, and we are just coming up on 1 o'clock, so I think we'll go ahead and end it there. Thank you both for sharing your time and expertise on this and your contact information. For those of you attending, we will get the recording and the slides posted on our website as soon as possible, so you have access to those to reference them. Thank you so much, and have a great day, everyone.